Hello everyone and welcome back. In this video I'm going to talk to you about guardianship and Baker Act and whether or not somebody who has become a ward, in other words there's a guardianship, a permanent guardianship over them, is able to give informed consent, in other words agree to be Baker Acted. So let's just take a step back for a second and talk to you about the Baker Act, because remember there's two types of Baker Act. The first being involuntary, where you're Baker acted against your will, law enforcement, qualified professional, or a court order, which triggers the 72-hour clock ticking. And then there's the voluntary Baker Act, where you go there, you supposedly give informed consent, and now you can be held indefinitely. And remember, you could be involuntary, right? At the end of the 72 hours, one of the options is you agree to be voluntary. Again, you're supposed to give informed consent. I'm not going to go over, all that issue again, but, needless to say, we've sort of talked about that a lot in past videos. But here's the issue. Family has gotten permanent guardianship over their loved one, which means they have been declared incapacitated, meaning they no longer have the legal right to make medical decisions for themselves because that right has been given to the guardian, which in this case was one of the parents. Now, we wanted to place this individual in a facility that we have great respect for. We really like this facility. We'd like to send more people there. But they said to us, we're not allowed to take this person on a voluntary basis because the voluntary admission section of the Baker Act says in order to come voluntarily, you have to give informed consent. And somebody who has been declared incapacitated is legally incapable of giving informed consent. Now, I said, I agree with you. That's exactly what the statute says, but here's the deal. They're not really coming voluntarily themselves. The guardian is making the decision for them, right? It's the guardian who now has the authority. The ward, the person who has had the guardianship placed on them, no longer has the legal right to make any medical decisions for themselves. So even if they wanted to be Baker acted on a voluntary basis, they no longer could. They cannot give informed consent. So one of the reasons to have guardianship is so that you as the guardian can start to make medical decisions for your loved one. Now, not to confuse you, but I'm probably going to do that anyway. Does that mean if we put somebody in a facility under a guardianship, they can no longer be Baker acted? No. They can still be involuntarily detained under a Baker Act if they meet criteria, meaning they need emergency stabilization. So what could happen is guardianship gets granted, person's declared incapacitated, the guardian, typically one of the parents, says, okay, you're going to treatment in this particular facility. They go there and then they have some type of mental health crisis and now they need a higher level of care. And so the facility does the right thing and sends them to a facility that can handle somebody who is, having a mental health crisis. They send them, to a Baker Act receiving facility. So they have been involuntarily Baker acted. Now, at the end of the 72 hours, can that facility have the ward sign a voluntary admission agreement? No. Why? Well, the statute says that somebody who has been declared incapacitated is not legally capable of giving informed consent, because remember, their right to make decisions for themselves with regards to their medical care has been taken away. It's been given to the guardian. And so I sort of wanted to share this with you because remember I sort of said in other videos that the Marchman Act, the guardianship, Baker, they work together. They're all part of this sort of behavioral health ecosystem, which is why I say to you, if you're going to put your loved one to treatment, you need to deal with a law firm that understands how all three of these statutes operate, who has tremendous experience with these three statutes. And it sort of goads me a little bit when I see other lawyers who do car accidents and divorce work and criminal work and other civil litigation, and they're sort of dabbling in the Marchman Act. It really somewhat goads me because this is all I do. And it's my mission, and I want to make sure that we get it right the first time, and you're not sold a bill of goods by some lawyer who's looking to make a quick buck, on you. I find that frankly offensive, but perhaps that's a different video for another day. The point I'm trying to make is that guardianship is a really powerful tool because it even prevents your loved one from agreeing to go voluntarily into a Baker Act facility or anywhere else for that matter, because they no longer have that legal right. That legal right belongs to the guardian. Okay, now, the reason I'm a big fan of guardianship is because even if there's a Marchment Act in place, if there's no guardianship in place, their ability to make medical decisions still remains. Now, there's a court order that says they will go to treatment, but it doesn't control anything else. So when someone tries to sell you, oh, it's a Marchment Act, it's a Marchment Act, and they shoehorn the case in, and I've seen that happen, if you need max control, the guardianship is the way to go. And you could do that with a Marchment Act, but the guardianship is the ultimate tool to get your loved one into treatment, make sure they take their medications, control their finances and other things that can lead to all kinds of shenanigans, and get them the help they need so they can finally experience lifelong recovery. So sorry if it was a little convoluted, but this is a new issue that came up and I wanted to share it with you. So thank you for tuning in. See you in the next video. Bye-bye.